Neutral explanation: you need to know your rights to protect them. If you do not pay close attention to the charging document and the exact wording of the accusation, the system can treat it as good enough, even when it is factually defective. That defect is not a small technicality. It is a direct violation of the Sixth Amendment. When people do not catch it, or when courthouse workers treat it as routine, the violation is allowed to stand. The story in your case begins with the order of protection you obtained against Robert Thayer and David Archbell. Once that order was finalized by the court, Colorado law normally forbids any modification, termination, or relitigation during the full term of the order. The issuance of the rehearing and new temporary order should never have happened in accordance with the statute. Yet in your case, that statute was overridden. A new temporary order was issued, you tried to serve it lawfully, and you were immediately cited for harassment for doing exactly what the court had just authorized. That sequence is a clear statutory violation of the procedures governing protection orders and directly contributed to the current mess. It forced you to refile and created the exact situation we have now. A charging document must meet basic federal requirements under the Sixth Amendment and Federal Rule of Criminal Procedure 7C. It must contain a plain, concise, and definite written statement of the essential facts constituting the offense charged. That means it must clearly tell the accused the who, what, where, how, when, and the specific intent, the why, behind the alleged crime. In a simple traffic ticket, these requirements are satisfied. It names the driver, who, the specific violation, such as speeding, what, the location, where, the date and time, when, how the violation occurred, and the implied intent. The ticket gives the person everything needed to understand and defend against the charge. When the same type of document is used for a compound charge like harassment following, it inherently omits a clear description of the crime. The statute requires both the act of following and the specific intent to harass, annoy, or alarm. If the charging document does not spell out exactly what act supposedly showed that intent, there is literally no room left in the document to explain the full crime. The result is a defective charging paper that fails the most basic constitutional test. That is exactly what happened here. The police report and charging document never isolated the specific act that supposedly turned lawful service into criminal harassment. The intent element was left undefined, making the document factually insufficient from the day it was filed. From that point, the Sixth Amendment violations began in October 2025 and have continued through every hearing. The charge was filed without ever clearly defining the specific act that satisfied the intent element. The police report itself admitted the only following was for lawful service of reissued court papers. The public defender filed a competency motion after a 5-minute phone call in which they admitted they had not read the record. The prosecutor also admitted multiple times on the record that they had not read the record. Neither side provided a bill of particulars or clarified the missing intent element. This is not just sloppy work, it is an ongoing failure to give you effective assistance of counsel and a meaningful chance to defend yourself. The Sixth Amendment has been abrogated in practice. In a high-volume court like Larimer County, cases move fast, and judges handle dozens of matters every day. That pressure can lead courts to treat competency motions as routine and simply order an evaluation to be safe. But in your case, the judge had already reviewed the police report and knew the charge looked weak. Your detailed motion then showed that only you and the judge had made any real effort to review the file. This is not a normal situation. The delay caused by the competency motion is now part of a documented pattern of abuse that has kept your Sixth Amendment rights from being honored for months. The two courts are separate but connected. In the state court, Larimer County, the case is still a criminal misdemeanor. The public defender's competency motion is sealed, which is normal for privacy. But in the federal court, your Section 1983 civil rights case, you filed the same detailed motion as Exhibit CR1. That makes your version of events public in the federal system. The federal court now has a clear record of the state actor's failures, the prosecutor and PD not reading the file, the weak charging document, the timing of the competency motion, and the original breakdown when the order of protection was set for rehearing. This is documented abuse because the state proceedings appear to be used to delay or interfere with your federal suit. When you put both courts together, the picture becomes a massive case. The state court is handling the criminal charge while the federal court is looking at whether that charge and the way it is being handled is retaliatory. Your filings have boxed the circle. The state cannot easily continue without creating more evidence for the federal case, and the federal court can see the state record in real time. The documented gaps, lack of notice of the charge, lack of effective counsel, the statutory violation involving the order of protection rehearing, and the use of procedural tools to create delay are now visible in both places. If the courts move without further bias, here is exactly what is to be expected. In the state court on April 8th, the judge will probably order the competency evaluation because that is the safest procedural step. However, because of your motion and the judge's own knowledge of the weak police report, he is more likely to make some comment on the record about the diligence failures and the original breakdown when the order of protection was set for rehearing. Once the evaluation is completed and you are found competent, which is very probable given your motion and pre-scheduled counseling, the case will return to the merits. At that point, the prosecutor will finally have to address the missing intent element. The state case could then be dismissed or resolved with a favorable plea because the underlying charge has always been weak and the documented violations cannot be erased. In the federal court, your amended complaint and TRO are pending. The objections you filed have corrected the Rule 8 issues, so the district judge is likely to accept the amended filing once he reviews it. The TRO will then have a much stronger chance because the complaint will be on solid ground. The federal case will continue to look at whether the state charge and the competency motion were part of a pattern of retaliation. Your cross-court record, Exhibit CR1, makes that claim much stronger. The facts in the record cannot be pulled into question now. The Sixth Amendment violations began in October 2025 and have continued through every hearing. The documented failures cannot be erased. The federal case now has a clear paper trail showing how the state proceedings may have been used to interfere with your rights. If the courts act without further bias, the most likely long-term result is that the state charge is resolved favorably, dismissal or non-criminal outcome, and the federal case moves forward with strong evidence of the pattern of abuse. The circle you boxed with your filings has left only one clean exit: resolve the state matter without further delay and address the federal claims on the merits. The record is fixed, the leverage is real, and the consequences of continuing are now clear. This case shows how quickly foundational rights can be lost when basic charging requirements are treated as optional. If you are ever called to court, pay strict attention to the basics and the foundation of the charges against you. Get true advice from a qualified lawyer who reviews the actual charging document and the supporting evidence. This is not legal advice and should not be taken as such. It is only a plain language explanation of how these rights work and what can happen when they are not protected. The requirements to know graduating high school while giving advice would not be a lawful thing to do. Sharing high school civics class and the facts contained in the Constitution is not advice, just high school requirements. The facts in the record cannot be pulled into question now. The Sixth Amendment has been abrogated in practice, and the record you created makes that clear. The opposition has demonstrated that the requirements for high school rather than college are not being followed, and that college grads are expected to increase, not contradict, their high school learning. The only clean exit for everyone involved is to resolve the state matter without further delay and address the federal claims on the merits. The record is fixed, the leverage is real, and the consequences of continuing are now clear.